This is an ABC News special report.
Good morning. I'm Whit Johnson in New York. We're coming on the air because the Supreme Court just issued its ruling in a Second Amendment gun control case challenging the country's ban on bump stocks. Those are the attachments which essentially convert semi-automatic rifles into automatic rifles. The Trump administration, you'll remember, issuing the ban following the horrific mass shooting in Las Vegas back in 2017 when Stephen Paddock used weapons fitted with bump stocks to open fire on a country music festival, killing 58 people and wounding hundreds more. The owner of a gun store in Texas challenging that ban. So this is a rare case of the Biden administration defending a decision by the Trump administration. And just moments ago, the court ruling the ban is unlawful. Let's get right to ABC's senior national correspondent Terry Moran at the Supreme Court. Terry, as we pointed out here, that rare case, it had some bipartisan support, but the Supreme Court says no, it's against the law.
That's right. This is essentially striking down what the Trump administration tried to do after the shooting in Las Vegas that killed 60 people back in 2017. The shooter in that case used one of these bump stocks. And this opinion really gets into the guts of a firearm, of a rifle, and how it works to draw a distinction between a machine gun, which have been illegal in the United States since 1934, and that 1934 law defines a machine gun as a weapon that fires more than one shot with a single function of the trigger. And a bump stock, which is not the same thing, according to the plaintiffs and now the Supreme Court of the United States. A bump stock uses the recoil of the rifle and the shooter's own manipulation of that pressure to achieve a very high rate of fire. The trigger continues to discharge the projectile every single shot. So it's not the same thing. I mean, right here in black and white, it's an opinion by Clarence Thomas. He says, we conclude that a semi-automatic rifle equipped with a bump stock is not a machine gun because it does not fire more than one shot by a single function of the trigger. Those words from that 1934 law. Now, the dissenters in this case said, well, the point of the function of the trigger was not how it works inside the gun. It's what comes out the end of the barrel. You can achieve a massive torrent of fire with both weapons, and they thought that this regulation passed during the Trump administration would cover both. But the Supreme Court says no, and so bump stocks, and there are hundreds of thousands of Americans who had them. They were ordered to surrender them or destroy them. Bump stocks are now legal once again in the United States of America.
Terry, thank you. Stand by here. I want to bring in ABC's senior Washington correspondent, Devin Dwyer. And Devin, I was just going back through some of these arguments from April, and this stands out to me, too, here. This from Justice Amy Coney Barrett. Intuitively, she says, I am entirely sympathetic to your argument, talking to the government here. But she says, I don't think the question is why didn't Congress pass that legislation to make this cover it more clearly? So to Terry's point, getting into sort of like the nuts and bolts, the mechanics of how these bump stocks work. Even during these arguments a couple months ago, the justices seemed a little bit confused about what would fit this definition.
Right. This law dates back to 1934, Whit, when the government banned machine guns that with the single pull of a trigger fire a huge spray of bullets at hundreds of rounds per minute. And what the conservative justices are saying here is that these bump stocks, as unsavory as they may be, as dangerous as they may be, as public menaces as many may see them, they simply don't meet the definition under federal law. And so she was sort of hinting that the government may want to rewrite that. You see in the picture here on the right of the screen is Jeremiah Cottle. He invented the bump stock. I traveled to Tennessee to meet with him, and he demonstrated for us just how these work. And he has insisted all along with that the single pull of a trigger does not release a spray of bullets. It requires an extra pull of the arm. And told me just yesterday that he continues to want to sell these. He sold more than 700,000 over the years that they were approved for sale. And the ATF, under the Obama administration, made that decision that they were legal. And now it appears that the Supreme Court has agreed with that judgment as well.
Devin, thank you. And of course, that horrific moment from 2017, investigators say there were several of those bump stock devices that were used to carry out that killing, some 60 people. This country, we've seen a lot of mass shootings. This was another level, and that's why it had that bipartisan support behind the ban initially. Let's bring in our Chief Justice correspondent, Pierre Thomas. From a practical standpoint, Pierre, what does this mean going forward?
Well, this obviously is going to concern many in law enforcement. As you said, the Trump administration and the Biden administration have been pretty clear that these bump stocks, in practical terms, even though the Supreme Court ruled that technically they are different, in practical terms, this allows a weapon to fire a tremendous amount of rounds. And we know that assault rifles are the primary weapon used in many of the mass shootings. So law enforcement will be looking at this, again, deeply concerned that, again, people who want to commit acts of mass violence will now be able to buy these things across the counter with no problem whatsoever.
Pierre Thomas, thank you. ABC News Supreme Court contributor Kate Shaw is joining us as well. And Kate, could this be open to challenges going forward? What's the future here?
Well, the ATF could try to do something different if it wanted to. I mean, the fundamental problem here is that the conservative majority, in the opinion by Justice Thomas, really focused on the words of a statute. And of course, that requires Congress to change if they're going to give the ATF different authority. But I do think you have sort of a theme in this opinion between the majority and the dissenting opinion, which is that the majority really views itself as the sort of the final arbiter of all legal questions. And it says there's a statute and we're going to decide what the statute means by reading the words closely. There are even some images, right, diagrams in the opinion of how these bump stocks work. The dissent says, well, really the expert agency, the ATF, is the body that we should trust to decide what kind of firearm policy is required, consistent with the broad statutes passed by Congress. And of course, here the majority has the votes, and so it wins. And so this regulation, again, as you said, a Trump administration regulation falls. And I suspect we are likely to see more decisions along these lines where agency decisions get overridden by the conservative majority on the Supreme Court.
All right, we will see how this plays out. Kate Shaw, thank you, and to our entire team. Again, the breaking news just moments ago, the Supreme Court ruling the ban on bump stocks is unlawful. We're going to send you back to regular programming now. For some of you, that's Good Morning America, and our coverage here on ABC News Live and abcnews.com continues. And then I'll be back later this evening with our entire World News Tonight team. Thanks so much for watching. I'm Wade Johnson in New York. Have a good day.
This has been a special report from ABC News.
And you're watching continuing coverage now on ABC News Live. First, after the Supreme Court ruled that a ban on bump stocks is unconstitutional. Bump stocks make a semi-automatic rifle fire more like a machine gun, but the justices ruled that bump stocks do not qualify as machine guns under federal law. The Trump administration banned those devices after bump stocks were used in America's deadliest mass shooting in 2017 in Las Vegas. That gunman killed 60 people and injured more than 500. Now, in a 6-3 opinion authored by Justice Clarence Thomas, the justices say that ban is unlawful. ABC News senior national correspondent Terry Moran joins me now, along with ABC News Supreme Court contributor Kate Shaw, for more. Terry, there was a lot of back and forth during the questioning in this case. The justices trying to really get to the bottom of being sympathetic to the plaintiffs in the case, saying they understand that the gun can do kind of the same amount of damage with a bump stock as a machine gun, but then getting into the technicality of whether it actually is one. So how did they come down with this final ruling?
Well, the majority in this case, in an opinion written by Justice Clarence Thomas, did it exactly that way, by getting into the details, getting into the guts of the firearm. They're, in his opinion, I don't know if you can see this, but there's plenty of diagrams of what goes on inside these weapons. And it is that should control the case, is what Justice Clarence Thomas says. And it's because the law covering machine guns dates from 1934 and says these words, that a machine gun is a firearm defined by the ability to shoot automatically more than one shot by a single function of the trigger. You press the trigger, a lot of bullets come out. A bump stock operates somewhat differently inside the weapon. It achieves a very high rate of fire, very similar to a machine gun, but not simply by pulling the trigger. You have to control. The bump stock uses the recoil of the rifle and the shooter's own manipulation of it, essentially holding it steady and using that pressure, keeping his finger down, but the trigger is still discharging every single bullet, just at that very high rate of fire. Clarence Thomas and the majority in this case said that's different than what Congress defined in 1934 as a machine gun. It's a different kind of operation. It isn't fully automatic. The shooter is still doing physical things to the weapon. In dissent, I'll just read you just one line from Justice Sotomayor. who says this is focusing on the wrong details. The details aren't the inside of the gun, it's what comes out, she says. It's the high rate of fire, which has caused so much damage in America. And she says, when I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. She's quoting that law. Because I, like Congress, call that a machine gun, I respectfully dissent. So that's the difference. The majority said it has to be a fully automatic weapon designed as such and built as such. This add-on, they say, does something different, doesn't fall within that 1934 law that banned machine guns. So hundreds of thousands of Americans who bought bump stocks, were told to destroy them or turn them over to the ATF, can now enjoy, if that is the word, I guess, for people who like these things, enjoy their bump stocks. They're legal once again in the United States.
Kate, this was a gun case, but not a Second Amendment case. Walk us through the legal argument here.
Sure thing, Diane. So that's exactly right. This is just a case about the meaning of this 1934 statute that prohibits machine guns. And the question is, if you have a gun that's not a machine gun, but you put a bump stock on it, and does that turn into a machine gun that can be prohibited, or is it still something fundamentally different and thus not under that old statute passed by Congress? So it's really a question about the meaning of the words of a statute and whether this regulation is consistent with that statute. So that's, not a constitutional question. That's not a Second Amendment question. But of course, the case is about guns, and we know that the majority of the Supreme Court is very sympathetic to gun rights and to the Second Amendment. So I do think that it kind of hangs over the entirety of the case. The justices, I think, bring a degree of skepticism to any regulation that seriously curtails the ability of Americans who want to possess certain kinds of guns or to modify their guns in certain ways, as is the case here. And so I do think the Second Amendment is an important background principle in this case, but it's really just a case about the statute's words. And I think the one other principle that's important here is the question about agency power and agency expertise, right? This was the ATF, that's the body inside the federal government that really has the expertise on guns. And they took a look at bump stocks and they said bump stocks do the same thing as machine guns, so we're going to reclassify them as prohibited under this statute. And in many eras, the Supreme Court would have said, well, that's an expert agency, we'll defer to their judgment, but that's not really the approach of the Supreme Court. They themselves want to answer every legal question, and here they decided ATF just got the answer wrong.
And I want to bring in our Chief Justice correspondent, Pierre Thomas. Pierre, what does this mean for the ongoing fight to combat gun violence in this country?
Well, the Supreme Court here in making what is a technical decision is now pretty much at odds with many in law enforcement who see these weapons as acting in practical terms like a machine gun, able to mow down significant numbers of people because of the rapid rate of the bullets coming out of the gun. So law enforcement had been very much in favor of limiting the access to these kinds of weapons because of the implications for them in terms of doing their job, confronting mass shooters. We know that assault-style rifles are the primary weapon used in mass shootings, if you will. And now the people who choose to do these kind of attacks will have this kind of mechanism at their disposal because they will be legal. Law enforcement will be regrouping and thinking about, again, how to better protect the public and themselves in mass shootings where these weapons may be involved.
And I want to bring in our senior Washington reporter, Devin Dwyer, who follows the Supreme Court very closely for us. Devin, is there another way this issue could go back before the court? Is there a window left open the way this ruling is worded?
There's certainly a way that the ATF could, in some other form, try to prohibit these, but it would likely receive another legal challenge, Diane. I mean, Congress, the easiest way to prohibit bump stocks would be for Congress to write it into federal law, and we saw in today's decision some suggestion that that would be the way to go if legislators and policymakers see these as so dangerous. I should say that I interviewed exclusively the creator of the bump stock, Jeremiah Cottle, earlier this year in Tennessee. He created the company that designed these, made more than $700,000 since 2009 when they were first approved by the Obama administration's ATF. And he told us just yesterday that he plans to go back into business with these, continue manufacturing these. Michael Cargill, the plaintiff in this case in Texas, we were at his gun shop. He plans to put them back on the shelves. And both of these gun owners and gun enthusiasts say these are, in their view, believe it or not, a safety device that people have been bump shooting for years from their hips and can jimmy rig their guns with rubber bands and other devices to spray bullets mimicking a machine gun, and this actually helps it perform more accurately. But I got to tell you, Diane, a huge disappointment for those victims of the Las Vegas shooting and the survivors. I spoke with them as well, and in fact, we're just getting reaction from the gun rights groups, Every Town for Gun Safety, hugely disappointed in this decision and saying that the nation will be much more dangerous now.
Pierre, what's the law enforcement reaction to that argument that bump stocks are arguably safer than if someone were to just try to rig their gun in some unofficial manner to essentially do the same thing?
Well, law enforcement is not a monolith, but I think it's fair to say, based on the fact that the Trump administration, ATF, put forth this regulation blessed by the President of the United States, and the fact that the Biden administration was also supporting keeping the bump stock ban in place, tells you that they had pretty broad support from law enforcement that this was okay to do, in part because law enforcement is thinking of this, again, in practical terms. Going to the scene and dealing with, let's say, a mass shooter who has one of these weapons. It essentially fires almost at the rate of a machine gun. That is what their concern has been, both the safety to the public, but also the safety of law enforcement who would respond to these mass shooters. Now, obviously, there are gun enthusiasts who say, look, they like to go out and just spray, trees and other things and do target practice with these kinds of weapons. Again, their desire to do that was at odds with public safety. The Supreme Court said, again, because these are technically do not operate in exactly the same way as prescribed by the 1934 law. They're not machine guns. Law enforcement would tell you that they operate in practical terms very much the same.
And Kate, given the detail that the justices went into here to dissect what makes a machine gun, what makes a bump stock, if there were an appetite in Congress, and we'll get to that with Terry in a second, but if it were there, how complicated would it be to come up with this law to make sure that the bump stock is defined well enough to withstand another challenge in the Supreme Court?
I don't think it'd be very difficult. You just could actually write a sentence or two that actually explicitly banned bump stocks, right? So we have that kind of ban on machine guns. It's, granted an old one, but you could pass a statute that did that. And then I think you would have a Second Amendment question probably, right? So I presume someone would file a challenge not to the regulation, but to the statute, arguing that that ban violates the Second Amendment. And we are, of course, in a whole new world since 2022 as to whether the Second Amendment even prohibits, even permits, rather, extensive regulations of guns, including maybe a congressional prohibition on bump stock. So I think the drafting actually would be pretty straightforward. And it is possible that you could get some bipartisan consensus. Remember, after that shooting, another terrible mass shooting in Uvalde, Texas, we had a bipartisan coalition come together and pass some federal gun legislation around things like red flag laws, closing a couple of loopholes. So, it is possible. So I could see it happening here, but I do think it would almost certainly draw a Second Amendment challenge. And I think we'll know more in the next week or two about exactly what the court is going to do with cases that are brought, are arguing that there's a Second Amendment problem, because we still have that case to be decided about whether the federal law disarming abusers, right, individuals under domestic violence orders of protection, whether that law survives a Second Amendment challenge. And I think we'll know more then about exactly how a ban on bump stocks, if Congress were ever to pass one, might fare before this court.
All right, so Terry, that's how they could do it. Is there an appetite for this? What are the chances that Congress actually will try to pass a law to ban bump stocks now?
Well, let's just look at recent history. And by recent, I mean the 21st century. You have long odds in the United States Congress if you want to pass any kind of gun control, although it's not impossible. After Uvalde, there was a significant gun safety law passed by Congress and signed into law over the vivid objections of the gun lobby and of many gun owners across the country. So it is possible, and in fact, Justice Samuel Alito, in basically a little one-paragraph concurrence here, he says that the Las Vegas was horrible, and he says it showed how terrible these bump stocks are, and he says there can be little doubt that the Congress that passed the law banning machine guns would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the text of the law they wrote is clear, Alito says, and we must follow it. So he says Congress can amend the law, Congress can act. And that's really where we are when it comes to bump stocks. As I say, they were very popular. You know, and Devin knows that. That fellow who invented them made a good deal of money. People like them, and people, even without purchasing a bump stock, are able to achieve high rates of fire by putting a band in their belt loop and controlling the fire in that way as well. So this is a product that people like, and once that happens, the gun lobby tends to protect that interest very vividly, and Congress tends to listen. So long odds against anything done on this until another mass shooting uses it.
So, Devin, what recourse, if any, does the Biden administration have now?
Well, as we were just talking about with Kate Shaw, Diane, I mean, they can attempt to go back and take another crack at a regulation. They could also try to do some sort of a legislative push up on the Hill, but that's going to be very difficult. I mean, this is an accessory. This is not, this is not actually a weapon. It's, as we saw in that video, I mean, it's very difficult for, yes, there's been some bipartisan support, but the gun lobby has been very intense. So we're seeing right now some reaction from gun violence groups saying that they are planning to make another run at this. They're planning to meet with the White House. They won't let this stand, but the short answer is there's no quick solution to getting these guns off the streets, Diane.
And Pierre, what are you watching for in the law enforcement community in terms of response to this?
Again, we will see if some of the law enforcement organizations weigh in. What they've done in some cases like this is just work through the administration, work through ATF, which is a law enforcement agency, to get some of these things done by executive order when it's clear that Congress may not have the will to make these changes. But I agree with my colleagues. I think right now the one option that there is legislation by Congress. And the question now is, was something promulgated by the Trump administration? Is that something that Republicans on the Hill can agree with Democrats is something that should be done?
And Kate, there are still several big decisions on the Supreme Court docket for this term. What are you watching for next?
Sure. Well, so we have the one other gun case that I mentioned, Rahimi, right? A huge case both about whether this really important federal law disarming domestic abusers will stand or the court will strike it down, as the lower courts did in this case. So that's a big one I'm watching in the same space. But of course, we have a number of other cases outstanding, two of them involving questions of, accountability for January 6th. You have the case involving former President Trump's assertion that he is immune from criminal prosecution in the case brought by special counsel Jack Smith against him, arising out of January 6th. And you have the other January 6th case, United States versus Fisher, involving another January 6th defendant, essentially asking whether the statute under which he was charged and a number of others were charged was properly used. And so we'll have big decisions about whether people will face, a type of legal accountability for involvement in January 6th that everyone has been waiting with real bated breath for, in particular because the case involving President Trump really, I think, will tell us whether there's any possibility of a trial before the November election. At this point, very likely no, because of the amount of time that has lapsed since the oral argument back in April. But if that comes out next week, there still will be a live question of whether a trial in the district court might resume. So, a lot still on deck before the end of June.
And Devin, is there any sense of a timeline for that Trump immunity case that could directly affect the prospects of a trial before Election Day?
Well, the special counsel, Diane, had been pushing the Supreme Court months ago to take this up expeditiously. They had been hoping and urging during an oral argument for the court to render a judgment before voters head to the polls back in May, and they have not acted. And I have to say, everything we've seen from the Supreme Court on this particular case, the Trump immunity case, has been, slow and steady as she goes. They do not appear to be in any big hurry, and I wouldn't be surprised, frankly, if we see that case come out in the very last week of June, maybe on the last possible day, Diane.
All right, Pierre Thomas, Terry Moran, Devin Dwyer, Kate Shaw, thank you all. And we will be right back with more of the day's top stories. Stay with us.
Whenever news breaks,
we are here in Israel, a nation at war after that brutal surprise attack by Hamas.
On the ground in Ukraine, reporting from Lewiston, Maine.
The scene of a horrific mass shooting.
ABC News Live is right there everywhere.
From the scene of that deadly missile strike in Dnipro, Ukraine. reporting from the earthquake in Turkey.
In rolling forward, this tornado tore through this little town.
From the most devastating disaster in Hawaii.
From Charleston, South Carolina, on the 2024 campaign trail.
In Iceland, let's go.
Traveling with the president in Mexico City.
Wherever the story.
From the front lines, from southern Israel,
outside the Gaza Strip,
in Beirut,
From the FBI.
Reporting from the nurses on the picket line.
Here at 10 Downing Street in London.
Streaming live to you.
Wherever the story is.
Wherever the story is.
Wherever the story is. We're going to take you there.
You're streaming.
ABC News Live.
ABC News Live.
you're streaming ABC News Live.
ABC News Live. Streaming free everywhere. America's #1 streaming news.
First thing in the morning.
There's a